This is The Law Show on CL 650. Now back to the show.
Yeah, and welcome back. And we're talking about estate law and estate planning with John Lakes and John White from LakesWhyteLLP in North Vancouver. And we're talking about what would seem like the most basic part of a will, which is just signing it at the end of the document. But you're telling me that you see a lot of situations where it's not done properly. So to recap, you have to sign at the end of the will, and you have to have two witnesses, right? And they have to be in the same room when everybody signs.
Yeah, and it's like, if you don't do it, it's like running a marathon but quitting the last 10 yards.
Yeah.
Because, if there is uncertainty, you got to go to court, and it costs a lot of money. Just to follow up what John was saying, there was recently 2 unreported cases where people, just before they committed suicide, they wrote handwritten notes, and they signed them, and they were deemed to be valid. Of course, also had to make sure that the person was competent at the time they signed it. But to go to that whole process of the court is costly, time delayed, and it could have been remedied by someone just, they go to all the trouble getting a will done, they should get it signed properly as well.
Okay, so is that the situation where the lawyer hands them or the notary hands them the will and then lets them go off and sign it on their own?
No, that you have to sign. Normally what happens when you're in a lawyer's or notary's office, there should be at least 3 people there. There'd be the person signing, so the person signs, and then the lawyer and the other person both see them sign, and then they sign.
So what I'm getting at is when does it fall off the rails? When is it?
Well,
one of the 2 witnesses didn't witness the other people signing.
All of a sudden, I've signed a will, and then I call my assistant in to come and be the second witness, and she hasn't seen me sign.
I see.
Well, another great example is one where the will isn't prepared by a lawyer. It's one of these drugstore off the rack wills where you fill in the blanks. And then people do all sorts of interesting things with signing them that don't comply with Section 37 of WESA.
Okay.
But there's a presumption if you have a professional person,
they're going to do it right.
Witnessing, like a lawyer notary, they've done it properly.
So you have you talked about a suicide note. Now you have some other cases here of signing wills. Can you give us a few examples?
Well, I mean, as I said earlier, you would think that it's not that difficult to go wrong with very, very simple rules, but people do. And for example, there's a situation where the will maker signed the will, and there were people there watching him do it, who were able to come to court later and say, yeah, I was in the room, I watched him sign this will. But for reasons that are never really explained in these cases, those people who watched him sign the will aren't the people who signed as witnesses.
Right.
And instead, in this particular case, the person who was assisting the will maker making the will went out and got 2 other people to come in the room and just sign as witnesses, even though they hadn't witnessed the will maker sign the will.
Mm-hmm. That's the whole thing about being a witness. You witness the signing of the will.
That's generally the point.
Mm-hmm.
And in this case, the court actually upheld it and would uphold it today as well, because the Act now says the witnesses, or the will has to be signed at its end by the will maker, or the signature at the end must be acknowledged by the will maker as his or hers in the presence of 2 or more witnesses. This is a case where both of these people who actually saw the guy sign the will came to court or provided evidence to the court and said, yes, I watched him agree that was his will, or that was his signature. So that was kind of an exception to the will. But it would have been so easy if these people had just signed it.
All right, I have a scenario where we live in a digital era, and someone pulls out their iPhone, and Grandma's sitting in the chair, and it's, Grandma, what are your last wishes for your estate? And they videotape Grandma there, and there's the 2 grandchildren of all these people around, and you have them all there, and you can see clearly who they are, and they witness Grandma's last wishes, but it's not a written document. Is that admissible?
I think you've got a problem there. There is a limited curative provision under WESA with electronic records of wills, which that clearly would be, but that section clearly defines what a record is, or I suppose it sets out what it includes. Includes data that is recorded or stored electronically, so we got that. Can be read by a person. Don't have that. And is capable of reproduction in a visible form.
Well,
Don't really have that either. There might be some wiggle room in the fact that the definition of record is inclusive. It includes that kind of a record. It's not necessarily limited to that kind of a record. It would be an interesting case, but it doesn't comply with what definition we have of an electronic record under Section 58 of WESA. And so I think there'd be an issue as to whether the court has the jurisdiction to receive that kind of evidence. But it's not a foregone conclusion as to how a court would
it
decide.
wouldn't be recognized as a will, because a will must be made in writing under WESA. So I mean, the law is quite often way behind technology, but and I think they're, even what they've accepted so far as testamentary documents have been written documents.
So it's still up to speculation as to whether
Well,
they would accept it.
I wouldn't rely on it.
No, I'm just saying, because I'm just saying we're living in this era now. Everybody's got a smartphone. You can record something, and someone say, well, let's just sit around and do it.
But there's also the issue that they can also edit information.
Well, there's also part of the problem there is what you just said. Let's just sit around and do it. The whole concept of all of these formal requirements of a will is it's supposed to reflect testamentary intention, not just intention, but something like a fixed and final intention of the will maker as to what's going to happen with their property after they die. It's not something you joke around with when you're drunk.
It's a sober thought goes into it, right?
Well, that's the idea.
And a will is dated too. It has a specific date on it, so it occurs at a specific time. And
so let's say we've done it properly. We have the witnesses there. You have to make sure that you have one will only, and what you do with it and where you store it and who you let know where it is. So you must have stories where somebody's done a will, but nobody knows it exists.
Well, that's an important point, because what's the point of doing a will if nobody can find it? So first of all, I always recommend to my clients that they file a wills notice with Government of British Columbia. So what you do is when you you prepare a will, there's a form the government charges $17. You put the date of when you did your will, your full name, your birth date, place of birth, and where you're going to keep your will. So Royal Bank at 17th and Lonsdale or whatever. So there's a record there. And then when somebody dies, before you can apply for probate, you have to do a will search, and then they give you a copy of the will notice. Now, you don't actually file a will in Victoria. You just
tell them where it is.
Where it is. So my practice is when someone comes in and signs a will, we do a will and then we do photocopies. And I usually recommend to them that they may want to give a photocopy of their will to the executor, so the executor knows where it is. And sometimes you don't want people to see your will before you're gone. But you make sure your executor knows where it is and when it's signed. Because
if you registered with the province and then it was done in your office, but nobody can find that, and you have a copy in your office, can they go to your office and use that one?
Well, I do. I mean, I have records going back to 1996, but 1986, but people retire. Like a friend of mine's just retired, and he's given us a bunch of his wills, the original wills. We don't have the copies, but eventually people lose track of people too. And I've had to deal with lawyers retiring who have an office full of original wills, sometimes going back to the 30s, where they've lost contact with the people, and people,
what are you going to do with them?
Yeah, what do you do with them? So
you've got it signed, you've notified, you've registered it with the government, and then in the last few minutes we have here, looking after the will, where to store it, and how you notify people. So what's your advice? Safety deposit box?
I prefer a safety deposit box, because if there's a fire in your house, it might get destroyed, but your executor should know where it is, and second level, they need to know where the safety deposit box key is, so then you don't spend, I don't even know what they charge now for drilling it. So they can, sometimes you might leave a copy with your accountant as well. Just as I say, you need to know where it is. And I've had estates where we've gone ahead and we think we've got the original will, and 2 months into the process, all of a sudden we found out there was a new will done 2 years later. So we've had to start the process all over.
That costs money.
It does.
So in the last minute or so we have here, We've talked about a bunch of stuff today, but the basic stuff is what we really want to get in the last minute here. The basics of doing a will and what do you have to do properly.
Get a professional to help you. I mean, this is the most important document you're going to do while you're alive, because it deals with your assets when you passed away. You worked hard to acquire assets, and you should be willing to pay a little bit of money to have it done. I mean, people pay more money for bath mats than they are for doing wills, and in this day of market, there's lots of people worth $1 million, and for less than $2,000, they could have it done properly, and then the family doesn't have to spend thousands of dollars fighting over whether a document is a will or not.
And then if it's done in your office, it's going to be witnessed properly.
Well, you would expect so, yeah. I mean, you want to make sure that the will reflects what your intentions are, and that it's clear and that it's signed properly. It's really no more difficult than that.
Thank you, gentlemen. It's been great chatting with you. John Lakes and John White from LakesWhyteLLP in North Vancouver, across from Capilano Mall. Quite easy to find, and free parking. I like that. We've been talking about estate law and estate planning on The Law Show here on CL 650. I'm Zach Spencer. I'll speak to you next time.